Good morning, everyone. We are going to go live with several civil motions this morning. I'm about to bring some people in here. I'm not sure what I've got here. Good morning, sir. What's your name?
Matthew Wade Shaddix.
Mr. Shaddix, I'm not sure why you're here in my courtroom, but let me see if I can figure it out. And I'll be back with you in a minute. Can anybody tell me why Matt Shaddix is in my courtroom in the middle of civil motions? Let's see what we got here. It's not on my on base. I had one guy who was here on the wrong day. Notice a pretrial. Did he get sent over here from the pretrial side? Sounds like he needs a lawyer. Sam, could you help me on that? They just hung up. Good morning, Mr. Welch.
Good morning, Your Honor.
I'm about to bring in Patrick Green. I had a criminal case that popped up on my screen that doesn't.
Let me close my blind so I don't look like somebody in the witness protection program.
Yeah, you do.
There, that's better.
I've got two matters, both set for 9. One of them should be quite brief. Patrick Green is here on the Ally Bank case. But let me let the clock tick for a minute and see if the parties show up on this other matter.
Okay.
And I'm not sure what happened to the criminal guy. He disappeared. We are live on YouTube, on the Zoom platform, and we are recording things. I've got a case where it appears the defendant has confessed the debt, so I'm not sure if anyone's even going to show up.
Renner, did you hear about Ed Annan, our former mayor and attorney in Kalamazoo?
No, I did not.
He just passed away Wednesday. Unfortunately, he got ALS, and it was like a rapid progression.
Oh, I hadn't heard that. I had a few cases with him over the years. His father was a car salesman at the Ford dealer.
Okay.
And he was pretty old when I first met him. And he was an interesting guy. And I won't say he had a lot of cases down here, but over the years when I was prosecutor and maybe early in my career as judge, I had a few cases with him. I'm sorry to hear that.
Yeah, I guess he has a son who survived, and I don't remember the other relatives that were mentioned in the paper article. It's in the Gazette for Sunday, Kalamazoo Gazette, if you want to see it.
Well, I used to get the Gazette now the Sunday Gazette is like $8.
Oh, I don't know how much it is digital. I think it's like 16 a month or 19 a month.
No, maybe I ought to invest. All right, it is 8:58. I don't know that anyone else going to check in here. We are live once again. I'm sorry to hear about Mr. Annan, member of our Michigan bar. This case won't go away. I was hoping it would go away, but it's taken on a new life. This is file 201153. It's entitled Ally Bank versus Leo Mitchell. Mr. Patrick Green from Dickinson Wright is here on behalf of Ally Bank, and Mr. Harold Welch from Legal Aid of Western Michigan is here on behalf of the defendant. The plaintiff was prepared to dismiss this action, but dismiss it in a fashion that was not acceptable to the defendant. The parties were at loggerheads over that issue. That was in June. The defendant wanted to file an amended counterclaim and ask for damages, attorney fees, and repair the credit. Defendant had 21 days to file the claim, and plaintiff had 21 days to answer the claim. Matter set for a status conference for today. Mr. Green has filed a response to the counterclaim, asked that it be dismissed. I feel we're fighting a battle over a postage stamp sized piece of real estate. Mr. Welch, what's your position here?
Yes, Your Honor. And I think the problem is, I'm not sure because, when we deal with organizations and corporations, I don't know where the decisions are being made. But all we requested was a dismissal with prejudice and that the credit line be repaired. Recently, I had email correspondence with a plaintiff's law firm and mentioned that if that type of an offer was made, I would recommend it to my client. I would say that I have authority, but I don't because time has passed. And what Ally Bank is doing is poking the bear. And at some point, my client is a pretty easygoing fellow, but at some point, I'm afraid if this continues, we're getting farther and farther away from a very simple resolution of this matter. And I regret that. I made notes to myself this morning. Don't say anything sarcastic or make any personal digs. I'm gonna stick to that. I don't think that would help. I don't want to throw gasoline on the fire, but I do want to communicate that I am somewhat baffled by the response of Ally Bank. I don't know how they consider their ethical responsibilities to the community, but they bought bad debt. It was fraudulent debt, and we're only requesting what it was fair and reasonable. So I am baffled by that. Thank you, Your Honor.
Mr. Green, what's your position here?
Judge, my Ally Bank's position is very similar to Your Honor's. We've requested a settlement offer. We haven't gotten one. What we think, in reviewing the counterclaim, we think that there's any number of legal deficiencies, and in lieu of putting the time and effort and the court's time and effort into a motion for summary disposition, we filed our answer preserving our defenses. And what we think would make sense would be an early mediation or some kind of settlement conference where we can clear the air and, as counsel said, really discuss what seems to be a reasonable resolution. Dismissal with prejudice, there are implications that go beyond that. I understand the allegation that the debt is bad and fraudulent. Like I said, I think there are significant legal deficiencies in that argument, but given the order of magnitude of the dispute and the possible options that the parties have at their disposal to settle it, if we could sit down and just really hammer out some kind of resolution, I think it would save both attorneys' clients and the court a lot of time and effort.
Well, that's a worthy suggestion, but I don't think it's going to work. I think I can put you guys in a room for 12 hours to mediate it, and we're at loggerheads. I have some reservations about the plaintiff's ability to even prove this claim. I think the car dealership no longer exists. I think the salesman that is at issue is in the wind somewhere. So I have reservations about whether the plaintiff can prove the case. On the other side of the coin, we have an elderly man with very limited resources who made a foolish decision to go in and try to purchase this car that he couldn't afford. And he's worried about his credit rating. He has no money. And so it's like we're fighting about something that one side or the other ought to fold their tent. But at this point, neither side is willing to do that. So we're spending lots of money in attorney fees and struggling to just put this matter to rest. I don't understand why the plaintiff won't grant a dismissal with prejudice. I don't understand why the defendant won't accept the dismissal that they've got. But I'm only the judge, and you're each representing a party with interest. But it just seems like a lot more effort than is really worth it. Mr. Green?
Yeah, thank you, Your Honor. I don't know that Ally's position is that it won't fold up its tent. I think that it's going to need something other than just the filing of a deficient counterclaim. We filed our answer. We reached out to defendants counsel and said, what will it take to make this go away? And they haven't to date made a settlement offer. I understand how that may sound like standing on ceremony, but it's, if you agree to give us everything that we want, we may be willing to accept that. And I think if we could start walking towards the middle, be it in a settlement conference, be it in a mediation or outside of the court, I think that everybody would be surprised at how willing, at least my client is, to find a reasonable resolution. Absent that, if I heard the statement that Ally's poking the bear. I disagree with that. I think that, in the absence of meaningful settlement discussions or some kind of settlement proposal, and, I apologize that I'm stepping into the case for prior counsel and wasn't party or privy to the prior conversations. We're left with no place to go but to litigate now that there are these additional claims, and it's outside of our abilities to just dismiss our claim now that there are the counterclaims as well.
Your Honor, may I respond to that? Because those statements are clearly counterfactual. What happened was, with prior counsel, I said, we'll be happy with a dismissal, just repair the credit line. They wouldn't do that. So then new counsel comes in and emails me demanding that I make an offer. And I say, if you offer to my client to dismiss with prejudice and repair the credit line, I'm sure I will recommend that to him. So instead of Ally Bank making an offer, they try to say we don't make an offer. So I'm kind of getting dizzy with what's going on. I do want to resolve this. My client doesn't have the time to do this. He is challenged with electronics, and he couldn't attend today because of that problem. So I'm just baffled, Your Honor.
Well, your offer has always been dismiss with prejudice and repair his credit. Is that correct?
That's correct, Your Honor.
And their position is they would dismiss without prejudice and didn't have the ability to repair the credit.
They said they would dismiss with prejudice, but not repair the credit.
Okay.
And at some point, he may have to replace his used car with another used car and need another loan. So his credit is important.
Your Honor, may I ask Mr. Welch a question?
Yes.
Is Mr. Mitchell still in possession of the vehicle?
No, he turned it over. He called Ally Bank within 3 days, and they picked it up.
Okay.
That's why we have pled that he revoked acceptance is one of our defenses.
Okay, thank you.
So, Mr. Green, you're, I think, third in line as counsel here. The only sticking point, and counsel represents that it's very important for the plaintiff to have his credit repaired. I'll just leave it at that. The only sticking point is to somehow remove this from his credit record. That's what this entire fight is about. The transaction, the man is elderly. He's somewhat limited. He went into this dealership, got in some sort of a transfer one car for another car, and was in way over his head, and immediately tried to revoke the thing, and the car was returned, and he was sued for a lot of money for a car that he did not have. And as I indicated, I believe the car dealership has gone out of business. The witnesses probably are unable to be located, and someone prior to you in representation of the plaintiff agreed they would simply dismiss it. That wasn't enough for the defendant. He wants his credit repaired. Someone prior to you in line says, we won't do that, which compelled plaintiff to file a counter complaint, which brings a whole new posture to this. I'm not sure they can find any of their witnesses either, other than the defendant. So we're fighting over whether or not the plaintiff would agree to repair the defendant's credit. That's the only sticking point. We've spent a lot of time, and the plaintiff spent a lot of money. The defendant hasn't spent any money, but Mr. Welch has spent a great deal of time and his effort on it, but this is very costly to the plaintiff. So if we have a mediation, Mr. Welch isn't going to change his position, and I don't know whether you're going to change yours, but his offer is the same as it's been 2 lawyers ago: dismiss with prejudice and repair my client's credit, and we'll dismiss our counter complaint. They wouldn't do that, which caused him to file the counter complaint in the first place.
May I interject one thing, Your Honor?
Yes.
One of the complications that is below the surface is that I can't get electronic authority from my client when I make an offer. So before I did have the authority. Some time has passed. And so I either need to bring him on the record to a stipulation to a settlement, or have him, and I don't know how he would appear. I don't know if Your Honor still has a room there where people can come in to the courthouse and appear by video. Absent that, I need to send him something in writing by mail that he can sign and return. And that was one of the reasons I was requesting that plaintiff's counsel make me an offer, because I'm pending authority for settlement offers at this point. His position probably has not changed, but I have to dot my I's and cross my T's.
If I may, Your Honor, I've heard everything that you've said, and my suggestion would be, and I think that this has been fairly in line with what I was requesting in terms of a settlement conference. If I could take my turn in line, understanding that I'm third here for Ally, and go back with the proposals that have been discussed, and I hadn't previously heard what Your Honor said, that defendant would also recommend dismissal of the counterclaim. So essentially, mutual dismissals with prejudice, walk away, repair the credit, and this whole thing goes away. If that is what defense counsel is suggesting or representing, he would recommend to his client, I can see if I can get the authority to do that, and hopefully we can resolve this matter in short order.
Yeah, I would be happy to recommend that to my client, Your Honor.
All right. We keep kicking this poor can down the road, and hopefully to get this case finally resolved. Mr. Green, you're very reasonable here in your representations, but you are right. You're third in line. And as Mr. Welch says, we don't know who the man behind the curtain is making the decisions on behalf of the client. But you stated essentially what the current status is. Mutual dismissals, repair the credit, and the matter would be resolved. I'm going to continue this for 2 weeks to give each party time to consult with their client. Certainly, if you reach mutual dismissals, you can simply file it and that will resolve it. Otherwise, we'll make a record on August, I hate to think we're already in August 16th at 9 a.m. Now that we're doing these hearings virtually, and once upon a time, Mr. Green, you had to drive down here from Detroit or get local counsel that wouldn't be as knowledgeable about it as you are. We're going to continue to do these sorts of hearings by Zoom. I don't know what every court is going to do, but these things are particularly well adapted to Zoom. The plaintiff never showed, or the defendant doesn't show up. He shows up only by counsel. He doesn't have the ability to log in electronically or otherwise, but he's going to need to be here at the courthouse unless you have his consent for this next pretrial. This is page 5 of my notes.
I will tell him for sure, Your Honor.
And would you like a representative from Ally present as well, Your Honor?
Not so much if you feel it's appropriate. If it's going to be dismissed, then great. But Ally's spending a lot of money on Dickinson Wright on a case that ought to just go to sleep.
If I could make one suggestion to Mr. Green, Your Honor, that might speed things up, if he just takes a simple SCAO dismissal, fills that out with prejudice, stipulation and order, and puts in there further orders that the counterclaim is also dismissed and that the plaintiff will repair the credit line and send that to me, then I can get it in a mail to my client, get it back. Of course, I'll still want him to come on August 16th, but if counsel is able to do that or has the time to do that, that would speed things up. Thank you.
Yeah, I don't think we're there yet, but should we find ourselves there, I'm happy to act accordingly.
All right. If we don't resolve this at the next hearing, I'm going to give everybody what they want. I'm going to block out 2 days and set this matter for a trial on the claim and counterclaim, and we'll try the Chinese water torture on the judge and see if that resolves the matter. All right. That's probably not politically correct these day and age, but anyway, hopefully we can reach a resolution. Otherwise, we'll just try it. I'm tired of pretrial after pretrial after pretrial where we're moving backwards. All right, let's see what we can accomplish between now and August 16th at 9 a.m.
Okay.
All right, thank you, Your Honor.
Thank you. Good morning, Mr. Nate.
Good morning, Your Honor. How you doing?
Good. I was going to do your case first, but you logged in a couple minutes late, so I just started that one. Yours was shorter, and it looks like it's going to be even more shorter because the defendant isn't here. This is file 21448GC. It's entitled PYOD LLC versus Darlene Martin. This is the time and date for a conference in that matter. Mr. Preston Nate is here on behalf of the plaintiff. It was set for a pretrial this morning. The defendant filed a response indicating she has no money and is in some dire straits. But as we know, lack of money isn't a defense to the fact that you owe the debt. may affect her ability to pay the debt, but she was personally served and she is not here. Are you going to ask for a default?
I think so. Just for, like you said, reviewing the answer and then the fact that she didn't appear today, I think we would request the court to allow us to file the default, maybe under the 7-day rule, give her one last chance maybe to file something, but
All right. Let's take a look. I've got part of this file connected to the last file. No. The claim is for $2,725.69. I don't have the sheet. Let me see here. For filing fee. Service fee doesn't, $59.52 service. What do you have for costs?
just usually we just ask for filing fee, service fee. I have the filing fee at 75.
That's
So with both of those together, it would be a total cost of $134.52.
$134.52 plus $2,725.69 equals, that's not right. 2,725.69 plus 75 plus 59.52. 2,008,602.21. Plaintiff will submit a default judgment under the 7-day rule.
Okay.
Does not appear that she presently has the ability to pay the debt, but this will bring closure to it, and the judgment would be good for 10 years if her circumstances change.
Right.
All right, anything further on that one?
Nope, I believe that's all.
All right, thank you. We'll see
You
you
bet.
next time.
Yeah, thank you, Your Honor. Appreciate it.
Well, we have a 9:30 matter, and we'll let the clock tick a bit. We'll shut off the record. Then we have a 10 o'clock matter. This 9:30 matter may be resolved. Well, I have a number of 11 o'clock sentences that don't appear in my on-base feed. I'll have to find those separately. That's a nuisance. I have 1, 2, 3, 4, 5, 6, 7 sentences that aren't in the on base. Let me refresh it. Hmm. Well, it's 9:27. No one is yet here on the 9:30. I got a feeling perhaps they won't appear. Defendant says, I have made payment arrangements at $420 a month for 5 months. That was as of May 7th. So perhaps the matter has been resolved or even paid off. Okay, my sentencers are now here. Thank you, Samantha. Hi.
Do you have court right now?
Yeah,
I have Judge Patterson's out.
yeah.
I have Matthew Shaddix and.
He logged into my courtroom and he had a pretrial and then he disappeared. He logged in from the jail, but he was, what do you want to do with him?
Well, he's entering plea. He wants to enter plea.
All right.
I told him if we have somebody that can see him today, we'll get him seen. Otherwise,
I'll see him. He doesn't have an attorney.
no.
It's what's the plea offer?
2 count. Well, he's got 2 counts of indecent exposure, but he's pleading to 1. Other one dismissed. Says he's got rehab hooked up for the time that he's released tomorrow. Is what he said. He's got to pay around rehab.
Well, all right. Get him into my queue and I'll see him.
Yeah, I'll go complete his paperwork and I'll get it to you. I'm not sure what timeline you're looking at.
I don't know. Let's see what I got from the jail. Dan Frazine has entered my waiting room. Let me see, Shaddix.
Yeah, I don't have his stuff. He's just, I usually tell him that you'll call him back whenever you have time.
He has a failure to appear. He doesn't show an out date. He's been in jail for 17
The
days.
failure to appear, he was sentenced to 5 days, it looks like.
I can't tell from looking at this.
Okay, are you in the jail roster?
He has a $2,000 bond on this indecent exposure case.
You go to charges. Oh. I thought you were in the web jamming.
I am, but I'm just in the roster.
Okay. Yeah, I just clicked on his name and then I went to charge and it shows that he was sentenced in it.
Well, let's see here. Oops. Disorderly. That's not it. 5 days credit, 5 on July 20th.
And then he had these 2 that he needed to be seen on.
All right, so he's already done the 5 days for that, so he's in jail in lieu of the $2,000 bond on this case?
Yeah, well, there's, well, the 2 charges, but it's the same case, 2 charges, 2 counts, I think. But yeah.
All right, I'm a little leery because I don't have an attorney, but I'll go ahead and put him in there.
Okay, I'll put his stuff in and then whenever you have time, you'll just.
I'll have
get him.
time here. Well, is he still in the arraignment room at the jail?
No, I always tell him to take him back because I never know when you guys are, I don't know your court dockets and I don't want to rush you into doing something.
Well, I can see him now. Good morning, Daniel. What case are you here?
Pardon?
Which case are you here on?
I have down Middleton as a arraignment.
In front of Judge Patterson?
Pardon? I got down you. Let me double check. Let me double check them right now. Have a good weekend?
Yeah, the weather was nice. Fairly low key. What's Milliman's first name?
Oh, it would be Patterson. Jason?
It's getting reset.
Yep. For some reason, I put an M next to it on my calendar.
All right. Anyway, check with clerks.
Do you have Gambrell for a delayed sentence at 11?
Yes.
Oh, he did his 3 days. I put notes in the ROA.
Okay.
So he's good to
those
go.
files were in my on-base queue. I think maybe
Okay.
Chris or something. Anyway, they're supposed to arrive. All
Okay,
right, I'll
thanks.
be back in criminal mode 11.
See
All
ya.
right, thank you. Okay, I'm gonna turn the record on. This is file 21488GC. It's entitled Crown Asset Management versus Kevin T. Miller. File number is 28488GC. It's set for a pretrial and hearing on motion for summary disposition. Plaintiff is represented by the Stillman Law Office. Counsel of record is Michael Stillman. The defendant is pro per. This is a claim for $2,225 plus cost and interest and attorney fees for a total of $2,246.43. I received a response from the defendant, date stamped to May 7th, stating I had made payment arrangements with the Stillman Law Office as follows: $420 a month for 5 months. The last month will be $420.91 payment. That was filed in May. I've heard nothing since, but no one is here for either the plaintiff or the defendant, which leads me to think perhaps the matter's been resolved. All right, I'm going to close the record, shut off the live feed while we get situated on what's coming next.